There are two ways that a person can get charged with a felony in New Mexico. The first is if you actually get arrested for a felony. In that case, you will see a judge, usually the next day, either in magistrate court or in metropolitan court. That judge is going to set your conditions of release. In New Mexico, we now have reformed the Bail Release Act so that the presumption is that you'll get released on your own recognizance. If the state is concerned enough that they'd like to keep the person in custody, they have to file a motion for preventative detention. If that happens, the person is kept in custody, the case is transferred to district court, and a district court judge will hold a hearing to determine whether you will be held without bail. The other way that a felony case can start is for when a person is not arrested. Instead, you might get what's called a target letter. This would be from the district attorney's office, and it would tell you that you're the target of the grand jury. It will say the date the case is going to be presented, and it will tell you what the proposed charges are. You have the opportunity to testify if you want to, but you certainly don't have to. In either of these instances, you need to immediately contact an attorney because your rights are immediately impacted. In the case of a target letter, you want to get an attorney so that they can look at what the proposed charges are and usually contact the district attorney on your behalf. A grand jury hears case after case that are presented by the district attorney. If you are the target of the grand jury, you are not allowed to be in the room while the evidence is presented against you, nor is your attorney. If you choose to testify, the only person that can ask you questions is the district attorney. Your attorney cannot object or ask you questions. However, if you have exculpatory evidence that you think could help you in your case, you can contact the DA's office and you can ask that that evidence be presented in the grand jury. It's very important that you get an attorney involved right away so they can take those steps for you. In New Mexico, whether a felony case proceeds through preliminary hearing or grand jury is actually up to the district attorney. They can do either of those things. So in the grand jury presentation, as I've already explained, the grand jury determines whether or not the case is going to be bound over, indicted in district court. In a preliminary hearing, what happens is the district attorney brings in their witnesses. So the police officer who investigated the case, if there was an alleged victim in the case, they'll bring that person in. The person who is the target is allowed to be in the room. They testify, they can present witnesses, their attorney gets to ask questions and ask questions of the target as well. At the end of that process, the judge then makes the same determination that the grand jury would make in the other type of presentation, and that is whether or not they believe that a crime probably occurred. If they believe that, then the case again gets bound over to district court. In other words, it gets indicted. If you're facing felony charges, there are a couple of important things you need to do right away. The first is to not talk about the case with anybody, and the second is to get an attorney involved in the case right away. There are some very important deadlines that happen in these cases. For example, if you are arrested and the case gets set for a preliminary hearing, that hearing may not happen. The state might not be able to get their witnesses there, or there might be some other sort of problem where in the 60 days they have after the date of arrest to present it for preliminary hearing, they can't get it done. So the state on their own will decide to dismiss it. That's a dismissal without prejudice. So they are preserving their right to later go back and re-present the case. And when they do that, they're going to do it through a grand jury. So even though the case has been dismissed, those charges may still be brought against you, so you still don't want to talk to anybody about that. An attorney can look at what the charges are from the beginning, see what investigation might need to be done, and also help you get into a better position, no matter what, whether it's a prelim or whether we think the charges might be represented at some point. It could also be a situation where you can do things to head off now the case being represented for grand jury somewhere down the line. So if that's something that has happened in your life and you would like us to take a look at it, give you some advice, give you some direction, we'd be more than happy to help you with that. Just give us a call, fill out an online case evaluation, we can evaluate your case and help you.